Director McCabe, can I ask you, do you feel confident at this point the FBI is fully cooperating with special counsel for any request in communication and setting up of the coordination between the offices for documents, work products, insight, anything the special counsel as they're trying to get organized and get prepared for the investigations they're taking on? Is everyone in the FBI fully cooperating with special counsel?
Absolutely, sir. I'm absolutely confident of that. We have a robust relationship with the special counsel's office, and we are supporting them with personnel and resources in any way they request.
Thank you. Admiral Rogers, this spring, NSA decided to stop doing about queries. That was a long conversation that's happened there. It's now come out in the public about that conversation, that was identified as a problem. The court agreed with that, and that has been stopped. What I need to ask you is, who first identified that as a problem?
The National Security Agency did.
Okay, so how did you report that? Reported that to who? How did that conversation go once you identified we're uncomfortable with this type?
So in 2016, I had directed our Office of Compliance, let's do a fundamental baseline review of compliance associated with 702.
Okay.
We completed that effort. My memory is I was briefed on something like October the 20th. That led me to believe the technical solution that we put in place is not working with the reliability that's necessary here. I then, from memory, went to the Department of Justice and then on to the FISA court at the end of October. I think it was something like the 26th of October, and we informed the court we have a compliance issue here, and we're concerned that there's an underlying issue with the technical solution we've put in place. We told the court we were going to need some period of time to work our way through that. The court granted us that time. In return, the court also said, we will allow you to continue 702 under the 16 authorizations, but we will not reauthorize 17 until you show us that you have addressed this. We then went through an internal process, interacted with the Department of Justice as well as the court, and by March we had come to a solution that the FISA court was comfortable with. The court then authorized us to execute that solution and also then granted us authority for the 702 effort.
So you reported initially to the court this is an issue, or the court initially came to you and said we have an issue?
I went to the court and said we have an issue.
And the court said we agree, we have a problem as well?
Jack.
And then it got held up, went through the process of review, then the court is now signed off on the other 16.
That is correct.
So how does this harm your collection capabilities to be able to not do the about collections?
So I acknowledge that in doing this, we were going to lose some intelligence value, but my concern was I just felt it was important. We needed to be able to show that we're fully compliant with the law. And the technical solution we had put in place, I just didn't think was generating the level of reliability. And as a result of that, I said, we need to make the change. I will say this, and the FISA's court opinion also says the same thing. I also told the court at the time, if we can work that technical solution in a way it generates greater reliability, I would potentially come back to the Department of Justice and the court to recommend that we reinstitute it. And in fact, the court acknowledged that in their certification.
When you say greater reliability, tell me what you mean by that.
Because it was generating errors. Our Office of Compliance highlighted the specific number of cases in 2016. And I thought to myself, clearly it's not working as we think it is. We were doing queries unknowingly to the operator in a handful of situations against U.S. persons. And I just said, hey, that is not in accordance with the intent of the law.
Yeah, clearly it's not only the intent, it's the actual statute
Correct,
itself.
right, the statute,
that we protect U.S. persons from.
Yes, sir.
This is foreign directed. So what I'm hearing from you is the accountability system worked.
Yes, sir.
That the issue rose up. We're collecting. We do have information on U.S. persons. We don't want to get that information. Immediately the process started going through to be able to stop it. The court then put the final stop on it. It was corrected, and then that's now cleared.
Yes, sir. And in fact, we're purging the data as well. Not only have we stopped doing it, but we're purging the data that we had collected under the previous authorization.
So the issue on 702, most Oklahomans that I interact with don't know the term 702. But if I ask them, should we collect information on terrorist organizations and terrorists overseas who are planning to carry out attacks on us and our allies, they don't hesitate. They say, absolutely, we should do that. Now, they don't want collection on themselves and their mom, but they absolutely want us to be able to target terrorists. And so the issue I think when we talk about 702 on this dais is a normal conversation back home, that if we miss something internationally, everyone says, I thought we were doing this. Why aren't we? So I fully appreciate the civil liberties conversation and the privacy questions. Those are things I'm also passionate about. And it's very interesting for me to be able to hear from you that you're passionate about and NSA is passionate about, to make sure that we're not collecting on Americans. So I appreciate that. And in this case, when it comes out in the public media that this has occurred, it actually shows the system itself worked. When there was a query going on that was collecting on Americans, it was stopped immediately, data's purged. But we're still continuing to be able to target on threats internationally. And I do appreciate that. Thank you. I appreciate you back the time.